Welcome to the Half Empty, Half Full Consumer Advocacy Radio Show. Listen in nationwide on the TanTalk and StarCom radio networks with your host, Lori Zook, the consumer champion. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to learn something new. Get smarter faster and avoid scams and fraud. All opinions are that of the host and guests, and all shows are for educational purposes only and not to be construed as legal advice. Here's your host, Lori Zook.
And welcome to the Half Empty, Half Full Talk radio show. I'm your host, Lori Zook. Each week, we'll be discussing problems and solutions, changing negatives to positives, and helping you, the consumer, to get smarter faster. My guest today is Storm Bradford of Mortgage Fraud Examiners. And Storm's been on the show a couple of times before. And we're going to be talking about what you as a consumer need to know about foreclosure rescue scams. Welcome to the show, Storm.
Hey, Lori. Thanks for having me.
Thanks for being on the show again. And why don't you share a bit with our listeners about yourself and your background?
Well, I've had a litigation support company now for about going on 35 years. And we basically help attorneys. We write briefs, motions, affidavits, complaints, jury instructions. We show them how to win novel-type cases. And about 7 years ago, going on 8 years ago now, I guess, we started getting enormous phone calls from attorneys around the country asking us, how do you win these foreclosure cases? So out of the litigation support company, we formed Mortgage Fraud Examiners.
Well, you know, you're going to kind of get a kick out of this because when I walked into the radio station today, there is a big brochure on the table that says FTC Facts for Consumers. Mortgage payments sending you reeling, here's what to do. And it talks all about knowing your mortgage. And I'm going to read you some of the things off shortly. But I want to talk about scammers because I see a lot of companies that offer foreclosure and securitization audits. What are they? And do they actually work to help a homeowner in foreclosure?
They're basically worthless. A securitization audit, if you will, or one of these forensic loan audits, as we tell our clients, in a securitization audit, they proclaim to tell you who owns your loan. I can show a homeowner for free how to find out who owns their loan, so they certainly don't need a securitization audit. And these forensic loan audits are basically, they look for federal statutory regulations, and in most cases, the statute of limitations has run for anything in those things to help you. So basically, they're useless.
Okay. So when you get to, let me give you a scenario. If I hire a company that offers a securitization audit, and I'm betting it's pretty pricey, right?
I've seen as much as $5,000.
Okay. So in essence, what is in that securitization audit is not going to help me in court at all, correct?
Usually it's about 60 or 70 pages of their opinion on the the mortgage foreclosure defense. They talk about MERS, they talk about securitization, and usually there's only maybe a paragraph on what they found within the securitization audit as far as who possibly owned their loan.
Does it really matter, though? The securitization, isn't that when, one bank sells it off to another, and they're supposed to do the proper paperwork? That's what
it really doesn't help you in that sense at all, because at the end of the day, a foreclosure is basically an allegation that the homeowner breached the contract. And that means that the homeowner failed to make timely payments. The contract's very clear. We promised as homeowners to the bank that if we didn't make timely payments, they could take our property. All the bank is doing is saying, hey, Storm, Lori, you didn't make timely payments. We want the property as you agreed to in the contract. So unless you're attacking that contract, nothing else is going to help you.
But what about the lost note defense? The other side.
Produced note, that kind of stuff. Every court in the United States has said that's nonsense.
All right, now, we're talking about scammers, but what do you think about loan modifications? You know, I see the HAMP and the HARP, and a lot of people don't know what that is, so maybe you can explain that a bit.
Loan modifications are, I wouldn't go so far as to call them a scam, but they really aren't helping the homeowner in the end. Matter of fact, the last statistic I saw on it was 60 to 70% of people that get loan modifications end up in foreclosure anyway. Most of these loan modifications, matter of fact, 40 or 50% of the time, loan modifications will actually raise their payment. But any arrearage is put on the back of the loan, so if you're underwater, you're further underwater. If you're not underwater, it possibly puts you underwater. And in 5 years, these loan mods recalculate. Matter of fact, there was a big article not too long ago about them. 5 years are up on a lot of these mortgages and how they're recalculating.
Right.
And these homeowners are back to where they were, square one.
So basically, a loan modification is unless somebody ends up making a lot more money to be able to pay, really it's just doing the same thing that got them into trouble in the first place?
Well, it can bring them some relief. Like, let's say for 5 years, they cut their payment by some percentage points or something like that and lowers their payment, and it gives them an opportunity maybe to catch their breath. But after the 5 years, it usually goes back to where it is. But any of that arrearage, so in other words, if your payment was $2,000 a month and you're only making $1,000 a month for 5 years, that $1,000 a month for 60 months gets put on the back of the loan. So now if your loan was $200,000, it's $260,000.
So in essence, is it better, do you think, to walk away from a home when that's happening? I mean, is the real estate market rebounding that dramatically? Is it a bad business decision?
It's not rebounding dramatically at all. And, before anybody should do a loan mod, matter of fact, there's criminal traps in the loan mods. If what they do is they make you fill out a new financial statement. And if that financial statement that you fill out to get the loan mod is not in correspondence with the original loan application you filled out to get the loan, they turn them over to the FBI.
Okay, so you can't lie. In other words, you have to tell the truth because they're going to compare it to the old one.
Correct. And what we tell people is it's kind of like when you want to get the loan, it's like a resume. You want it to look good. Now you want to get a loan mod or a short sale or something like that. You don't want it to look that good. So people, make some changes on it. And if there's discrepancies there, these banks turn them over to the FBI, and you may get a knock on the door you don't want to knock on a door
right.
from.
So you need to be truthful, obviously. Now, what about ads I see for mortgage elimination? What is mortgage elimination?
It's basically a scam where these it's been around for a while. These individuals that basically they some of them call it the administrative process, or they have a lot of different names for it: bill of exchange, redemption certificates, and so forth. Basically, what it is they put this scheme together where, because you're the trustee on the trust, you created the trust. They tell you that you're allowed to remove the trustee and replace it with your own trustee, and then that trustee, they send a letter to the bank, and they say, if you don't answer this letter within 30 days, you agree to what we say, and what they say is a bunch of nonsense, and the banks don't even pay attention to them, and then they say, okay, well, you didn't answer within 30 days, so therefore you must agree to all this, and then the trustee calls the bank, puts in the land records that the loan's been paid in full, and what ends up happening is these people that do it, the homeowners that do it, they've gone to jail in droves.
Because there really is no such thing as mortgage elimination, correct?
They're falsifying documents in the courthouse is what they're doing, basically.
Well, let me ask you, I've also seen things for, I think it's called a land patent.
Yeah, land patents is all nonsense as well. We happen to call them patriot nut jobs. There's a lot of these people that they have all of these weird theories that the government, they don't have to follow the law, they don't have to pay taxes, the government has no jurisdiction over them and all this other stuff. And it's just all nonsensical arguments.
All right. Now, I've also heard of something called the straw man theory. Is that different or same thing?
Same thing. More of this nut job stuff. Okay.
Now, what is a mass joinder lawsuit? I saw that on your website.
What they'll do is they solicit homeowners to join in this mass joinder lawsuits, and who's making the money is the law firm. Let's say they tell everybody that they're going to charge you. I mean, we've seen it as much as $10,000 in fees to a homeowner to get involved in this lawsuit. And it's basically nonsense. They make a bunch of ridiculous arguments based on crazy legal theories and so forth, and none of them have worked.
Okay. Well, I want you to stay with us. We're going to take a short break, and we're going to come back and be speaking with Storm Bradford.
No pleasure cruise. I consider it a challenge before the whole human race, and I ain't gonna lose. We are the champions, my friend.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed. Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
I've paid my dues time after time. I've done my sentence, but committed no crime. And bad mistakes.
Welcome back to the Half Empty, Half Full Talk radio show. I've been speaking with Storm Bradford of Mortgage Fraud Examiners, and we've been talking a bit about scammers with the foreclosure rescues. Now, Storm, I've also heard about lease buyback programs. Maybe you can explain that to our listeners and tell us about it.
Yeah, that's another one where you have certain individuals will contact homeowners and say, look, deed your house over to me, and we'll go ahead and lease it back to you. And the majority of time, the homeowner just ends up losing their home.
So really another waste.
It's just another waste. It's another scam.
All right. Now, I mentioned when we started the show, when I walked into the station today, someone left a brochure called FTC for Federal Trade Commission, Facts for Consumers, what to do with your mortgage payments when you're in trouble. And it talks about how when you're behind on your payments, you have some options. And it also mentions things that you can do to avoid default and foreclosure. So basically it says that you can reinstate. You can do reinstatement. You can do a repayment plan. You can do forbearance. Any comments on any of those options?
Yeah, I mean, that's all something that homeowners can look at. It's basically, you can, if you're in default, you have a right pursuant to the contract in order to pay it back, but you just can't pay back, monthly again. You have to pay back the whole arrearage, which a lot of people can't do. There are forbearance agreements where sometimes what the bank will do is, depending upon your situation, if you had a death in the family, you were ill or something like that, they may say, look, I'll tell you what we'll do. the money that you owe us, we're going to put on the back of the loan and start making payments again. Any type of thing like that will help a homeowner, and it's something to obviously look into. There are all types of things that, but you just got to ask. You got to go to your servicer and just say, hey, look, how can you help me out here? I had this problem and I didn't make the payments for whatever reason. How can you help me? And they'll tell you. There's, again, forbearance agreements and other types of situations that they may try to set up for you that would be helpful to you.
Now, I understand, you read articles in the paper, you hear people talk. How difficult is it to get hold of, the bank, the servicer, to make that type of agreement? Because you hear about how you call and you get one person and then they pass you off to another person. Has that changed at all?
Not really. What you have to be careful with is most people think when they call the bank that they're talking to some bi-speckled gentleman in a white starch shirt and a gray flannel suit and a paisley tie. Most of the time, they're talking to someone with purple hair, a razor blade in their upper lip, tattoos all over their body, making $8 an hour. If you're talking to someone and you're not liking what they're saying, ask to speak to their boss. Okay.
Now, can bankruptcy save a house that's in foreclosure? Because I've heard yes and I've heard no.
Basically, well, again, it's one of those things. Possibly it could, but in 99% of the time it won't, because what you have to do in a bankruptcy is not only pay back, make your mortgage payments. You have to pay back the arrearage. In Chapter 13 bankruptcies, the longest it can go out is 5 years. So what eventually happens is, let's say you haven't made a payment for a year. Your payment was $2,000 a month. You owe $24,000. You have to pay that $24,000 back in the 5 years, plus make your mortgage payments.
Okay.
And most people can't do that.
Right. Now, I also hear about principal balance reductions. Is that ever possible? I mean, if I went out and bought a house a few years ago for $300,000 and now it's only worth $150,000, is there ever a shot of getting them to reduce that principal balance down to what it's worth?
Very rarely is that ever going to happen, and that's why we tell people that you need to get your mortgage examined. You need to see if there's things there that you can use against the bank that basically puts you in the driver's seat instead of them. What everyone fails to understand is a bank does not have to give you a loan mod. They do not. The government can't force them to it. The government actually will pay them $1,800 to do loan mods, but nobody can force them to do loan mods. They don't want to do loan mods. So at the end of the day, you're not in a position of power. We basically say that a loan mod is synonymous with begging. I don't want to go to somebody and beg for something. I want to be able to go to somebody and say, look, be in the power position, say this is what you're going to do or we're going to sue you. Okay. And that's what examining these mortgage transactions will do to help somebody, achieve that position and that position of power.
All right. Now, for people who have no money and they're still in trouble, some legitimate options would be a short sale where they sell the property for, less than they bought it for, or turning it in, right, on a deed in lieu?
Yeah. What we tell people is that two things. 90% of the time, there are things within these contracts that will help you go up against the bank and put you in a power position. If you happen to be one of those people that fall into the 10%, or you don't have the funds to get your loan examined, deeds in lieu of foreclosure and short sales is a very viable methodology for them, because Fannie Mae, Freddie Mac, USDA, VA, FHA will all guarantee you financing in 3 years or less if you do a deed in lieu of foreclosure or short sale. Realistically, in 3 years, you could get back in the game, buy a house, 3% down with a 580 credit rating, and possibly, in most instances, buy a comparable house for less than what your mortgage was.
Right, I understand. Now, I do some research on your website, and I've heard you say it many times. You use the term pretender defender. What do you mean by that?
Well, basically, these are attorneys that are making stall arguments, and they make the stall argument for one reason only, and that is to line their pockets with money. What these attorneys will do, there's been many articles written about it, what they will do is they'll charge a client, for the sake of argument, $3,500 up front and anywhere from $500 to $1,500 a month until they're foreclosed on. They make these arguments, produce the note, securitization, MERS, robo-signing, and so on. They're only stall tactics. Everybody that makes those arguments eventually loses their home. But it's something where this attorney's making money off of just of stalling. And probably the saddest part of it is, on a nationwide basis, the average time from when a homeowner defaults and they're actually put on the street is 3 years if you do nothing.
Okay.
So you could literally pay nobody anything and be in your house for 3 years before you get booted out. Well, here you have these attorneys leading you to believe that they're going to have some sort of defense that is going to save your home, when in essence they're just making arguments that all the courts have found to be frivolous.
Yeah, it's interesting. I've had lots of friends that have been in that situation, and the first thing that I say to them when they've hired a foreclosure defense attorney is, did you ask them how many cases they've won? And they look at me like I'm crazy, but it's a question that they don't ask.
Well,
and
you
then
got to be careful. It's not, and you got to define a win, because what these attorneys will tell you is, like, there's one attorney down in Tampa who says that he has saved thousands of homeowners their homes. Well, in 2014 alone, we know that of at least a dozen people that used him as a lawyer have lost their homes. So, and he makes the same arguments on all of them. So he's not saving anybody their home. He's just basically stalling. But you got to ask them what a win is. A win is not getting a case dismissed without prejudice where the bank comes back and re-forecloses. A win is when you're getting some sort of financial settlement from the bank or free title to your home.
Okay, now how do you find out, what the track record is? If you want to hire an attorney, is it possible to find out what their track record is if they say they won? How do you do that?
There is. In a lot of counties, they have online dockets, and you can go to a county, go to the clerk of the court docket, put in a attorney's name, and then look up the cases and see what's happening. Matter of fact, I had somebody call me one day, and I said, pick 3 people he was from Florida, and I said, pick 3 people that you know of, and I'll look them up for you. And we looked the 3 attorneys up that he gave us, and every one of their cases that were not currently live, that had been closed, every one of them had ended in a foreclosure.
Okay, so sometimes what they're saying is you're defining that when they say it's a win, a lot of times a win to them is just that they're stalling it. They actually haven't won money for the client. They haven't won the house for the client. They've basically won the hearing in that they've kind of held it off.
They held it off, or the case was dismissed with prejudice, which means that the bank can come back and re-foreclose. I'll give you an example. About a year ago, I had an attorney. I was on a national radio program, and this attorney had heard me on the program, and he called me up, and he says, look, I want to take umbrage with you. You made a statement that these arguments, produced the note and assignment and so forth, were useless. And I said, no, I didn't say they were useless. I said they were stall tactics. And he said, well, did you just see this Supreme Court case that came out of Ohio where the Supreme Court overturned a foreclosure? And I said, yes, I did. I said, let me ask you a question. How much do you think it cost that homeowner to get to the Supreme Court of Ohio? $20,000, $25,000? And he said, well, let's say $20,000. And I said, okay, we're in agreement, it's $20,000. We're also in agreement that the reason why the Supreme Court turned it over is that the bank filed the foreclosure action before they actually had received assignment of the note.
Okay.
And so we're in agreement on that. I said, now, don't you think now that the bank has the real assignment that they won't come back and foreclose? And he went, oh, my God. And I said, matter of fact, the justices even said this does not preclude the bank from coming back and re-foreclosing. So what happened at the end of the day, the poor homeowner ended up spending $20,000 and got booted to the curb anyway.
All right. Now, you're talking, okay, about how the bank could come back. I want to go back. Are you familiar? There was a case, I think it was U.S. Bank versus Bartram, which I believe now, at least here, I'm not sure if it's all over or just in Florida, it says that if the bank didn't show up at summary judgment, here in Florida, there's a 5-year statute of limitations on debt collection. Now they're saying that if the bank didn't show up, they can go ahead and try to foreclose whenever they want. So there's no statute of limitations. Have you heard that?
Well, the reason why is that every time you miss a payment, the statute of limitations starts again.
Okay.
And so if, you got to remember something again, a foreclosure is an allegation the homeowner breached the contract.
Okay.
Every time you don't make a payment, you breach that contract. That's why that case, the justices in that case basically came back and just said, hey, look, there is no 5-year limit because every time you miss a payment, it gets extended.
So it just keeps going and going.
It keeps going and going and going.
So people...
And rightfully so, because think about it. I tell homeowners, I say, look, put yourself in the position of the creditor. Put yourself in the position that you lent the money to somebody. The law is made easy for the creditor to get either their money back or their collateral because it's not fair to the creditor to have to, let's say they lent $300,000 on a property, it's not fair to the creditor to have to spend $100,000 to get his money back.
Okay.
So the laws are made easy for the creditor, as well as it should be.
Okay, I understand. Now, attorneys who fail to examine the mortgage transaction, which is a contract, are they committing malpractice? Because we're going to talk about what you do in the last segment. But should they be looking at the actual mortgage transaction, and what else should they be examining?
Absolutely. Again, the bank is alleging that the homeowner breached the contract. Therefore, it's a contract dispute. We did a press release, beware of the latest foreclosure rescue scam, pretender defenders, and I already knew what the law was on it, but I said, well, I'm just to have some other things that for people to consider. I called 4 or 5 bar associations around the country, and I asked them all the same question. I said, if someone comes into an attorney's office in your state with a contract dispute, and that attorney fails to examine that contract for breaches, errors, tortious conduct, set-offs, and the like, is that malpractice? The same word was used by all 4 or 5 of them. Absolutely.
All right. Now, I want you to define what contract law means as opposed to, real estate foreclosures when it comes to attorneys, because should the attorney that's handling the foreclosure, obviously they shouldn't just be stalling out. Are you saying that a lot of attorneys are not really doing what they're, what the consumer is paying them to do?
Well, the consumer doesn't know any better. Most consumers, when they go into an attorney's office, they're going in there thinking that this lawyer can come up with some defense for them to save their home. And the majority of them, these pretender defenders who are making these stall arguments, they're not. And therefore, they're committing malpractice.
Okay, and we actually...
what the bar associations are saying, that they are committing malpractice.
Yeah, we did a previous show with Bob Hurt, who's a consumer advocate, and he actually did... we did a show on... suing attorneys and one on suing judges, because I think a lot of people don't realize if you have to have actually the evidence, right, to support suing a lawyer or a judge. And I'm sure it's very difficult because, they're in the legal profession.
Judges, you can't sue and get monetary damages, number one. But lawyers, you sue their malpractice carrier. I'll give you an example. We have a client that and this isn't the first one we've had, but we have numerous ones. But this client paid this attorney $30,000, and she lost her house. And the attorney talked her into getting a securitization audit. She got it. The attorney made arguments based on the securitization audit, and she lost her home. So we did an exam for her, and we found all kinds of problems with it. And literally, this lady can get free title to her home. And I said, you can do it one of two ways. You can either go after the bank, and or you can go after your attorney as well, because he committed malpractice. And she said, well, I'm really happy with what I've got now, and I don't want to go after the attorney. It's just open old wounds, and it's going to cost money, and blah, 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 blah. And I said, look, you don't want to give this guy a free pass, because if you do, he's going to do it to somebody else. And I guarantee he already has. And she goes, yeah, he has. He took the $30,000 from me. I lost my home. He took $25,000 from my sister. She lost her home. And he took $30,000 from my best friend. She lost her home.
Yeah, that's
and I said,
sad.
You're going to give this guy a pass? I said, God belongs in jail.
But you know what? A lot of people do. They don't. They may not have the energy. If you're dealing with the foreclosure situation, they're being beaten down. I think, in sense, and they might.
They
not
are,
do
and then especially if we've found something for them that they can use with the bank, they're just happy now to negotiate with the bank and get something. So it's just like, well, I'm happy I've got something now anyway. But in doing that, they're giving this guy a pass. They should at least file a bar complaint.
Yeah, I agree. Now, I want to talk about some of the cases you listed on your website. There's one that says the jury gives the homeowner $1.25 million, and it was a Baltimore native who defaulted on a subprime loan, has been awarded $1.25 million in damages from her lender, Wells Fargo Bank. How did that happen? Because you don't hear about a lot of these cases.
Well, they're drowned out by all the scammers that have these different blogs with all the nonsense they throw out with all these different crazy arguments and so forth. So they kind of get drowned out. There's been dozens of multi-million-dollar awards, and every single one of them were based on some sort of a breach of contract or an error in the contract or some tortious misconduct within the contract.
Now, is it expensive to have an attorney to fight these? Because, you have to differentiate here. We were talking about a lot of lawyers just do the stall tactic. So those are foreclosure defense, whereas really somebody needs a foreclosure, an offensive litigator.
Correct.
And here in Florida, you don't get a lot of that. A lot of them don't want to go to court to litigate.
Well, here's the nice thing about what we do. And every one of these contracts, there's a clause that says that if the borrower finds anything wrong with this contract, they have to give the bank an opportunity to take, quote, corrective action.
Okay.
So they have the exam done. We even give them a sample grievance letter, and they basically cut and paste all the problems that we find into the letter and send this grievance letter to the bank. Now, the government has made these banks have a system and process in place to handle these grievance letters. So once they get these letters with all the problem areas, they really can't take corrective action because it's too late. All they can do is settle with you in some way, shape, form, or another. So 99% of the time, you don't even need an attorney. I could give you some examples. We had one lady. She had been turned down 3 times for a loan mod. She had hired one of these pretender defenders she paid $10,000 to, who pulled some complaint off this Living Lies website and filed that. That got dismissed. So she sued the bank and lost, turned down for 3 loan mods. We did an exam for her a week before they were kicking her out of her house. We did an exam for her, and they came back. They settled with her. They cut her payment from I think it was 6.7. It was either 6.75 or 7.25% interest rate loan. They knocked it down to 3.3% for the life of the loan, and forgave all the arrearage.
Okay, so that's a case of a win, correct?
That's a win because she got a financial settlement.
Okay, gotcha.
See, and actually, we had another one Iowa, and we did the exam for the guy, and he called us back, and he had an attorney, and he called back and said, Storm, he says, the bank just offered us $75,000 and cash, and they were going to, do some sort of settlement with his interest rate and so forth and so on. And he was all excited about it. And I said to him, I said, well, obviously neither you or your attorney read the examination. And he said, yeah, we did. And I said, well, no, you didn't. I said, because if you did, we put the court case in there where a homeowner with the exact same factual scenario as yours got millions. So you can take what you've got, because in the normal parlance of things, it would be a great deal. But if it was me, I think I'd be going for the millions.
Right. Now, does filing a complaint with the Consumer Financial Protection Bureau against the bank do anything? And I can tell you, I've had clients who have utilized that service, and typically they get a response back within 24 hours, which is pretty quick.
Yeah, they do. The problem is that, again, you have a lot of these scammers out there, a lot of these pretender defenders out there who, that people are calling up and making these stupid things. Well, my loan was robo-signed and this, which doesn't matter. All the courts have ruled those cases are nonsense. But they get about 4,000 complaints a month.
That's tremendous.
And they're not, and that's just not on mortgages. They take care of all other types of credit type things as well. But what we do is in our examinations, we now give a list of all of the people to contact, their contact information and everything. So we're telling them, look, just don't contact this group, contact all of these groups.
Okay, and they should do it by certified return receipt mail, so they have some type of proof, right?
Well, there's online complaint forms with a lot of them, but you'll get some sort of answer from several of them.
Okay. And
we even, in a lot of instances, will find things and we'll even tell them to contact the FBI because of some of the stuff that we found in these contracts.
Yeah, I mean, I'm not an attorney, but I've seen some interesting things coming my way as a credit consultant. And then I have to send it to an attorney because I'm not one. But sometimes it's kind of scary, some of the things that you see or discover. There are a lot of realtors and appraisers and that work together.
Well, that's what we tell people. Like when they come to us, we say, look, you got to understand something. You breached the contract. You have to overcome your breach. And you have to find wrongdoing by the other side. Now, who's the other side? The other side could be the homeowner that sold you the property. It could be the real estate agent. It could be the mortgage broker. It could be the bank. It could be the title company. It could be the appraiser. It could be any and sundry group or individuals that could have exposure to you.
Right. And Storm, I'm going to interrupt you just for a second. We're going to take a quick break, and then we're going to come back and go through this. So stay with us.
My friend, keep on fighting till the end.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. You can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed. Do you suffer from back, neck, or body pain? Do you suffer from migraines or have jaw or face pain? Has conventional medicine failed you? Were you injured or in an accident? Call chiropractic physician Dr. Dan Maddock at 813-935-1664. Dr. Dan has helped thousands of patients gain relief for more than 30 years. Dr. Dan is caring, gentle, and takes his time with each patient. He's also a past president of the International Craniopathic Society, a special certification of only 300 chiropractors worldwide. Dr. Dan helps patients from the neck up and the neck down. Dr. Dan accepts most insurance plans. Don't continue to live in pain. Call 813-935-1664 today. That's 813-935-1664 and get on track to better health.
I've paid my dues time after time. I've done my sentence.
And welcome back to the Half Empty, Half Full Talk radio show. I'm your host, Lori Zook. and I've been speaking with Storm Bradford of Mortgage Fraud Examiners. This is a pretty interesting show because I want to cover what I haven't covered so far, which is what does Mortgage Fraud Examiners do?
Well, what we do is we ask homeowners to, obviously, we charge a fee to do it, but we ask them to send us every single piece of paper that deals with their mortgage transaction. That means all of their closing documents, their appraisal, any correspondence to include emails, any notices of default, any substitutions to trustee, any loan modification attempts, any forbearance agreements, any short sale attempts, any court cases filed, any bankruptcies, any nonsense they may have bought, like a securitization audit or anything like that, because the more that they give us, the more of an opportunity that we have to discover something for them to use against the other side. And as I said before, happily, over 90% of the time, those things are there. They exist.
Okay, now, I saw something, I think on your website, that talked about a defect in the mortgage. What's a defect in the mortgage?
Well, a defect could be an error. We had a client in one state that in the contract, they made the mistake. It was it was a 100-acre farm. And they made the mistake, and they put down 10 acres.
Okay.
Well, they had foreclosed on this woman, and they took all 100 acres. And when we did the examination, not only did we find that wrong with the contract, there was other things. There was appraisal fraud and other types of things. But this was very specific because the contract, pursuant to the contract, they were only supposed to take 10 acres. They took 100. Well, the bank basically, when they got their letter, was, how much do you want and where do you want us to stack it?
Right, because you actually got them. It was obvious.
Got them. So there's errors, there's breaches of contract, there are, tortious conduct like appraisal fraud, broker fraud, title company fraud. I mean, there's all kinds of different, I could be here all day explaining all the different ways and problems there are with these contracts.
All right,
and what we find a lot of, too, is sometimes we found not only was a problem with the original contract, they had gotten a loan mod, and there was a problem with the loan mod. The bank breached the loan mod agreement. So there's always, as I said, 90% of the time, actually it's more than 90%, but, we don't try to blue sky. We just basically say what it is. The government and their statistics, they did some examinations of some mortgages and found it was 83% of the time they found problems with the mortgages. And they also did another study where they looked at the appraisals, and they found that 76 of them, there were problems. Well, when you add 76 with problems with the appraisals and 83 with problems with the mortgages, it's over 100%. So we find appraisal fraud basically corresponds with the government found on their appraisals 80% of the time, and so that and the other problems that we find with the contracts, you're well over 90% the majority of the time.
Okay, now I know, a lot of these companies that offer the forensic audits or securitization audits, a lot of times they're people that maybe were in the mortgage business, or it might just be someone, that doesn't really know anything. Who does it? Who does this legal examination for you or your employees?
Well, as I said, I've had this litigation support company for over 30 years, and it's a combination of retired attorneys, practicing attorneys, law professors, retired judges, and everybody. This is who is part and parcel of getting these examinations done.
Now, how can a consumer find an attorney to utilize this information? Because you don't actually represent them, right? Your company.
What we do is we tell clients is we're kind of like a company that does an MRI or a CAT scan. We're going to examine the body. We're going to tell you what's wrong with it. Now, you can either, if it's something that's not terribly egregious, you can do it yourself with these do-it-yourself methods. We have a whole section, the last part of the examination deals with how to do it yourself.
Okay.
But when you're talking millions and things like that, you're going to need an attorney because the bank's just not going to cut you a check.
Right, and I think it might be hard for people without some type of legal background to represent themselves pro se, right? Because above small claims court...
No. You never want to represent yourself pro se for the very sake of argument. The facts could be on your side. The law could be on your side. The bank lawyers would beat you procedurally.
Right, because you don't know the rules of civil procedure, right?
Yeah, what we tell people to do is, like I said, we have this whole section, Procedures for Resolving Mortgage Issues, is the last section of our report that we give them. And, we talk about legal aid, self-help legal aid, notice of grievance and issue escalation. We talk about free services that are out there and what you can do on your own. So there's plenty of stuff there for people to do. And again, unless it's a situation where you're talking millions of dollars, this is something that homeowners can do themselves.
Now, let's say we have attorneys that are listening to the show, and maybe they have clients and they're interested in working with you. How do you, if they're doing the stall tactic and maybe they want to actually try to win a case and go up against the bank, is it something that you help them with? Do you teach it?
Well, the attorneys that are doing the stall tactics don't even want to know about us for the very simple reason is that, I guess, and explain it this way. If you have a result on this report where there's plenty of stuff to use against the bank, 99% of the time these things end in a settlement. So let's say the attorney charges $250 an hour, and he writes a demand letter and makes a phone call or two. He might use up 3 or 4 hours of his time.
Okay.
So let's say he uses up 4 hours of his time. That's $1,000.
Okay.
Or he could charge somebody $1,000 a month, install it for 3 years, and make himself over $30,000.
So basically, the attorneys that are doing the monthly billing while they're on a retainer, they might not be doing that much work, is what you're saying. But
they're not doing any work. This one that I told you about got hit up for $30,000. I asked her, I said, I bet you had, what your attorney did, I bet you, correct me if I'm wrong, but I bet you had about 3 or 4 telephonic hearings, and then you got foreclosed on. She goes, you're right. She goes, I think it was about 4 telephonic hearings, and then we got foreclosed on.
Okay.
And I said, well, think about it. You paid the guy $30,000. And for that, you got, and I said, how long were the telephonic hearings? She goes, I don't know, 5 or 10 minutes. So I said, okay, let's give them the benefit of the doubt that they were 30 minutes for all 4 of those telephonic hearings. You paid that guy $10,000 a minute.
Whew, kind of a scary number. That's
very
frightening.
Scary.
Now, we got about 2 minutes. What else should consumers know?
Is not, don't look for a boogeyman. Look for what it is. Look for the fact that the homeowner breached the contract. That's what the bank's alleging. They have to overcome their breach, and they can go to their servicer and say, hey, look, is there some sort of workout? Is there some way we can work this out? Don't be afraid to correspond with your bank. And again, if you've got somebody on the phone and they're uncooperative, whatever the case may be, ask to speak to their supervisor. Go up the chain until you get somebody that has some reason, logic, and common sense. But if you can, the best thing to do is examine that mortgage transaction so you're now dealing from a position of power.
All right. Well, I want to thank you for joining me, Storm. How can people get a hold of you?
Well, our website is mortgagefraudexaminers.com, and our phone number is 1-800-540-EXAM, and that's 3926. The numbers for it. And, feel free to call us. We don't charge anybody to talk to them. Matter of fact, we tell people every day that I don't care whether you use us or not. Give us a call. We'll try to point you in the right direction and, hopefully bring about a satisfactory resolution to your problem.
Great. Well, thanks again for joining me. And
always a pleasure.
yeah, it was great. And join us every Thursday night at 11 p.m. for a new Half Empty, Half Full Talk radio show. Learn something new every week and get smarter faster. Be safe.